And certainly, I think, from my knowledge of the Australian regulatory framework, and certainly looking at what I've seen from the Productivity Commission review and the Henry report, the absence of a central register of charities seems to be an absence in terms of giving the public the sorts of information that you're talking about.
Yeah, thank you. Is there, how many employees do you have in the Charities Commission?
David Locke speaking. At the moment we have 460 employees. We're based over 4 sites. We receive just over 29 million UK pounds per year funding from the Treasury. We're a non-ministerial government department. We report to Parliament for our work and we report to the courts for our decision making, but we're funded directly from Treasury.
Okay, thanks very much.
This is Senator Eggleston and the Chair. I would just like to ask you to outline the impact on mainstream religions such as the Catholic Church and the Anglican Church that the establishment of your Commission has had, if any.
Joanne Edwardes speaking. Well, of course, the Charity Commission has been in existence for a very, very, very long time. And there's a very long tradition and history of charity law in England and Wales that governs religious organisations. And I say, by and large, you know, we've had a good relationship with religious organisations, particularly the mainstream religious organisations. As David Locke was explaining earlier, a number of these have quite recently come under our regulatory control by dint of the need to register as charities. Previously, they were excepted from that requirement, and the Charities Act 2006 has sort of altered that position. But nevertheless, you know, we've had a very long-standing relationship with mainstream religious organisations, and there are many, who've successfully registered for many numbers of years, and there's sort of new types of organisations also coming onto the register as well. So we've certainly kept up to date with the changing nature of charities that are advancing religion, and so have a very long-standing relationship with them.
David Locke speaking, and as in Australia as well, much of the charitable activity and many of the charities that we have in the UK were established by faith-based organisations, and increasingly over time the sector has become part secularised, but it is only part secularised, as well as having organisations, faith-based organisations that are for the advancement of religion. Many churches and faith-based organisations provide a range of different community resource and community action in areas of social welfare and deprivation as well. So we have a similar but different composition to the sector, really, as in Australia, and we think it's very important that we whilst we recognise there's different heritage to many of these different charities, it's important that the regulatory framework we have applies equally and fairly, and we understand how organisations are structured and operate. But we have, on the whole, we have a very positive relationship with faith-based charities in England and Wales.
There's a paragraph that I might read to you from the Australian Catholic Bishops' Conference, and it is this: the public benefit test used by the United Kingdom Charity Commission is problematic. Having reversed the presumption of public benefit, it is sought to develop criteria to measure public benefit. For example, with respect to independent fee-paying schools, it assesses public benefit by reference to such matters as community access to facilities and availability of scholarships for those who have insufficient means to pay the fees. Such criteria are arbitrary: how much access, how many scholarships. And it goes on to say this approach is not consistent with the original purpose of a public benefit requirement. This was not a qualifying test, but a disqualifying one. Would you comment on those words, please?
Joanne Edwardes speaking here. Certainly it's fair to say that one of the greatest areas of discussion and debate around the public benefit requirement in England and Wales has been around the question of the effect of fees and charities charging fees for their services. And this was an area where we did actually produce some supplementary guidance, specifically on public benefit and fee charging, for this reason, because there was such a great deal of interest and concern. We obviously have been at pains to explain, both in our general guidance and our supplementary guidance, how we have derived the principles in our guidance from the existing charity law. And our view that these tests are not arbitrary. They are principles that are derived from case law, and we've published a detailed analysis of the law that underpins all of our public benefit guidance to explain the case law that these principles come from, and that includes the principles in relation to fee charging. And as I say, we've explained that in some detail. Obviously, there may be organisations who don't agree with our interpretation of the law, but we've explained where we believe it comes from in the law, and have clearly spelled that out.
That hasn't been a problem for the mainstream religious organisations in the United Kingdom?
Joanne Edwardes said, certainly not. The issue of fees was something, of course, that was considered, as it is a fundamental aspect of the public benefit requirement. It was considered for all the charities that we did the independent public benefit assessments on, which included 4 mainstream religious organisations, and fees in those cases was not an issue or caused any difficulties. And all of those 4 organisations that we used for illustrative purposes all clearly demonstrated they met the requirement. In some cases, with regard to other sorts of charity that we reviewed, which were the residential care homes and independent fee-paying schools, there were a couple of those organisations that didn't fully satisfy that aspect of the public benefit requirement, and we've been working with those organisations to see what they can do to change the way in which they operate so that they can satisfy that requirement. And that's a kind of ongoing piece of work that we're doing with those charities. But even in those cases, it wasn't a case of us saying, I'm sorry, you're not charitable. It was a case of us saying, this is what you need to do to satisfy the requirement, and we work closely with them so that they can do that.
Thank you very much. Senator Xenophon.
Thank you.
So, Xenophon, on this point, the New Zealand Charities Commission indicated that if someone was dissatisfied with a decision of the New Zealand Charities Commission, they could appeal to the High Court. What's the appeal process against a decision of the UK Charities Commission?
Most of the decisions that the Commission makes are... Sorry, David Locke speaking. Sorry, Senator. Most of the decisions that the Charity Commission of England and Wales make are appealable to a charity tribunal, which was established under the 2006 Act as well. And that was established really to give a quick and cheap form of redress to individuals and organisations that were dissatisfied with a legal decision of the Commission. So, for example, a decision not to register an organisation on the basis of public benefit would be appealable to the charity tribunal. Similarly, if the Commission took any regulatory action against an organisation on the basis that it wasn't charitable, then that regulatory action would be appealable to the charity tribunal. And there is a subsequent right of appeal from the charity tribunal through to the court as well.
The charity tribunal, who sits on the charity tribunal, and how do you determine who's appropriate to make those decisions?
David Locke speaking. It's an independent tribunal that's established as part of the Independent Tribunal Service in England and Wales. It has a president who is independently appointed through the Ministry of Justice, There are legal members as well as lay members of the tribunal. There are now two tiers to the tribunal, and it depends on the nature and complexity of the decision that's going forward. So the most cases will go to the lower level. Some decisions will automatically go through to the higher level, which is normally a High Court judge or member of the judiciary who will sit in that capacity.
Thanks.
But it's very much independent of the Charity Commission.